Hey everybody, John Skiba here, and in this video I'm going to share with you something that I've never done before, and that is I'm going to show you how to actually draft a brief or a motion that's going to be filed with the court. But if this is your first time here to my YouTube channel, go ahead and click subscribe, click on that little bell, that way you'll be notified each and every week when I provide a new video that'll help you deal with your serious debt problem. All right, I'm going to attempt something here that may be a little difficult to do, but often I get in the comments and I get questions and emails about all of the all these topics and strategies and approaches that I talk about here on the YouTube channel. People get them and they understand why they should prevail on these different arguments, but the difficult part is actually drafting the document, putting pen to paper, if you will, and knowing what a motion looks like or how to respond to summary judgment. And so in this video, I'm going to do that. I'm going to take you through a sample brief or a sample response motion that I did to a motion for summary judgment and walk you through the different parts of it so you understand really what the court's looking for. It's important to understand that judges and other attorneys, they read these things all day long and they get used to things appearing a certain way. And so if you're doing that differently, it's going to throw off the system a bit. You also may not be getting in some of the most vital information that you need in a motion to be able to prevail before the court. So I'm going to walk you through this. It's going to be a little bit different than normal. We're going to actually be looking at a Word document, but I'm hoping that this is helpful as you try to defeat these junk debt buyers and deal with this matter through court. So let's go ahead and jump into that now.
Okay, so if you're going to write like a lawyer and draft your motion like a lawyer, what's important to know is really kind of how to get around a typical legal document, because judges and other attorneys, they're used to writing and seeing arguments presented in a certain way. So what I want to do initially is show you how a written motion or a response to a motion is put together. So this is just a kind of a template response to summary judgment. I just made up Portfolio Recovery Associates as the plaintiff, and then a John and a Jane Doe as the defendants. But I want to show you really what to expect in the document and how things are typically laid out. Now, this is page 1 of a response to a motion for summary judgment. You're going to see here in the upper left-hand corner, this is the name of the law firm that's representing one of the parties. Now, if you're representing yourself, your name and contact information is going to go up here so that they know who's actually drafting the document. So in this case, I work for the law firm of Jackson White. I have my name, I'm going to have my email, my telephone number, all that kind of stuff. Then at the top center, we have the name of the court where the document is actually being filed or where the case is being held. So, for instance, this case is held in the Superior Court in the county of Maricopa here in the Phoenix area where I work. And so we put the top of the caption. That's what this area is called here, is the caption. At the very top center is the name of the court. Then on the left side of the caption is the names of the parties who are involved. So again, this is just a made-up case that I created this document for. So we have the Junk Debt Buyer Portfolio Recovery Associates versus John and Jane Doe. And then to the right side of the caption, we're going to have a case number. Often civil cases have CV, meaning they're civil, that's the designation. And then you would put the full case number there. Below the case number is the title of the document. So for instance, in this case, we're saying this is the defendant's response to a motion for summary judgment, just so that the court clerk and the judge know exactly what it is that they're about to read. Then we just go through some introductory things where we're saying, the defendants, in this case, they have counsel, me, through counsel, and pursuant to the rules that we're citing here, submit this response to Plaintiff Portfolio Recovery Associates, motion for summary judgment. Now, the way I lay out my motions and my responses, I always do an introduction section. I once attended a continuing education class that talked about the introduction as kind of just a free-for-all. This is where you can really lay out your argument, lay out what the reader is going to learn as they go through this. Because you got to realize with judges, they have a very limited amount of time to read these things, and they have a ton of documents. And so they're constantly reading through these documents and they want to get through them quickly. So in the introduction, I always just give them kind of a roadmap of where this is going to go. I start, you can see on this motion, the response to summary judgment, I put PRA, Portfolio Recovery Associate. Their motion for summary judgment must be denied for 3 reasons. 1, they failed to show an accounting, that an account, I got a typo there, belonging to Mr. Doe was ever transferred or assigned to Portfolio Recovery Associates. The second reason I'm saying even if they were able to show it, the account was transferred, the statute of limitations has expired on a large number of the payments, and 3, they have failed to provide a calculation of damages. So right out of the get-go, you're seeing, I'm telling the judge, there's 3 reasons why you've got to deny summary judgment. I'm going to discuss these in detail as we go through this, but you need to know where I'm going with this right from the beginning, catch the judge's attention, and then kind of lay it out as you go through this. So usually the introduction can be as short as a paragraph. I usually don't go much more than about page and a half, that kind of thing. And I always end it with a paragraph of saying what exactly it is I want the court to do. Summary judgment standard. Again, this is a summary judgment motion or response to summary judgment, but this could be applied to really a motion to dismiss or any other type of motion. I lay what the law is out right here as far as summary judgment. Again, this has Arizona case law in it, so it's not going to be applicable to everybody's situation. But I let the court know, hey, here's what the standard is that you need to be evaluating this with. Next, we have a facts section. Particularly if you're responding to summary judgment, it's important to lay out all the facts that are relevant and to show that there are facts that are in dispute between the parties. And so I go through here and show, and like I said, mine's pretty short as far as what the underlying facts are. Then we get into the legal argument section. And here I'm going to break down what my various arguments are. And I love using headings and subheadings and keeping the paragraphs relatively short. In this age of social media and everything's on the internet, people's attention span, including judges, is not that long. They want to be able to skim through this pretty quickly and be able to navigate the document fairly quickly. So I usually start with my first argument. Again, if you remember in the introduction, I had 3 reasons why summary judgment should be denied. I'm going to lay them out in that exact same order. Here I talk about Portfolio's documentation. I go through each of their exhibits explaining why they're not applicable. You can see this, I don't know if you can see this very clearly, I even will cut and paste parts of the documents or the exhibits that the debt buyer has. If there's something that I think is really relevant, I will literally cut and paste and put it into the Word document so the court is really focused in on what I'm trying to state is missing in this case. Like for instance, in this case, they always say that the accounts that are transferred, the loans that are transferred, they're listed on Exhibit A or Schedule 1, or this one said Schedule 2. Well, this is what Schedule 2 looked like. It says transferred loans, and then it's on file with this other company, FMC, but there's no tying of Mr. John and Jane Doe, in this case, to that particular transfer. So I wanted to highlight that to the court. And I go through the other exhibits, just explaining what's wrong with it. Now, I can tell you, I also touch on whether things are hearsay or whether there's other objections that should be submitted. Let me scroll down really quick here and show you an example of how most legal writing is done. Back in law school, they teach, most legal writing professors and courses will teach writing in a specific way. And the method that they follow is you have to explain what the rule is and then explain how the rule is applied to the facts of your case. I remember my law school professor, she always called it R-E-R-A. And she would write that on their papers. R-E, rule explained, and then R-A, rule applied. So you'll see here, I'm talking about the statute of limitations in Arizona. Pursuant to ARS 12-548, the statute of limitations on a written contract is 6 years. I go through, I cite what the law is. This whole paragraph is telling the court what the law is. And then I go into the R-A, the rule applied section of my argument, and I apply the facts that are specific to this case to the rule that I just explained to the court in the prior paragraph. Excuse me. So I did that, and then I also did it here when it comes to damages. I discussed what the rule is here in Arizona under this Wells Fargo Bank case as to proving damages. And then you can tell when I start doing the rule applied section because of this little word here. I'm saying here, in this case, I'm taking my facts and applying it to that law that I just explained to the court and letting you know why I think it is that they should rule in my favor. And then the final thing you're going to do is a conclusion. Again, the conclusion is very similar to the introduction. This is where kind of this is just pure, what I had a professor tell me, this is where you're just doing pure advocacy. You're not having to be constrained by specific citations or anything like that. You're just saying, hey, this is why I think this motion should be denied or why I should win my motion. So I'm going to go over that one more time. Let me just scroll up to the top. So when you're looking at a motion or some kind of brief that you're going to be submitting to the court, at the top, the first page is going to have the contact information for whoever is drafting it, whether it be the lawyer or whether it be you as what we call a pro se or a pro per defendant. We have the caption, which contains the court name, the parties' names, case numbers, and the title of the document. Then we jump right into the introduction, where we're going to tell the court exactly what's happening. And then if we go down a little further, we're going to get into what the legal standard is. You probably won't have this in every single case if you were just responding to a standard motion to dismiss. But in summary judgment, I like to let the court know that, to remind them that they've got to hedge their bets essentially, or give my client the benefit of the doubt under Arizona law. Then you're going to have a facts section, which is important to lay out what the facts are. You've got to remember, these judges, like I said, they read thousands of these things. They don't remember your case from one day to the other. You're living this nonstop. They're not. And so in order to be able to bring them up to speed, you need to make sure that they have the relevant facts without going overboard. And then we jump into the legal argument, where you're going to go through and you're going to outline why it is that the court should rule in your favor based upon what you put in the introduction. And again, remember that format that I showed here with the statute of limitations of the rule explained, rule applied, RERA. Explain what the rule is, and then go ahead and apply that rule to the facts of your case to show the court why it is that you should get the ruling that you're seeking. Again, we did that here with damages, rule explained, and then rule applied. And then you can wrap it all up with a conclusion and stating very specifically what it is that you want the court to do.
All right, I hope that was helpful. I hope that gives you at least some idea of where to go. If you're sitting down at a computer, you have all this information, you've been doing legal research over at Google Scholar, or you've been getting statutory information from the Cornell, from their website. You're doing all that stuff, and now you're like, okay, now I've actually got to put it together. This can at least give you some type of framework to know, as far as understanding what the court expects and how to lay out these arguments in an effective way that'll help you to win your case. Thanks for watching today.